Good evening, ladies and gentlemen, and welcome back to another program here on Legally Speaking. My name is Jamali John, and I'm very happy to have you guys with me for another episode of this program. I want to begin by thanking you guys for watching these programs and for sharing them. I noticed that for our video last week, we're almost at 200 shares. So I gather that the programs have been beneficial to you. And I want to thank you very much for sharing it with others so that it can be of some benefit to them too. I also want to thank my sponsor, Be Well Pharmacy, for sponsoring these videos. And I hope that these videos will continue to be of some use to you as you listen to them and take note of some of the things that I am presenting. This video is intended to be part of a 4-video series, and so it is really a continuation from the video that I did last week. Last week we spoke about intestacy, we spoke about what that means, and naturally what would happen if you die without making a will. Now this week I want to pick up from last week, and after last week's video someone messaged me to ask me a question, and I think it's important for me to start by answering this question in this video, and I will build from there. Now the question that was asked after last week's video was, what is the position of stepchildren? Last week I touched on what was commonly referred to as legitimate and illegitimate children, children born inside of wedlock and outside of wedlock, and I mentioned that there's no difference in benefiting from an inheritance under intestacy between children born in and out of wedlock. So someone messaged me and asked me, what about stepchildren? If my mother was in a relationship with a man who is not my father and he passes away, do I stand to benefit from his estate if he died without making a will? Now the answer to that question is no. And that is why in the video last week, I was careful to go through how you are able to establish that you are a beneficiary by presenting some certificate to establish that relationship. And so in circumstances where you are not in a position to present that birth certificate, you would not qualify as a beneficiary. And so I want to specifically mention here that if you go back to last week's video, you would notice that I also spoke about the position of the spouse. The spouse. And so in case you missed it and you did not pay attention to that specific word, I want to mention here that common law partners would not benefit under the laws of intestacy. There are some jurisdictions, even right here in the Caribbean, where common law relationships are acknowledged, and this is because common law relationships have come to be a part of our community, our countries, and so some jurisdictions have gone ahead and acknowledged those relationships, but here in St. Vincent we do not, under the Administration of Estates Act. And so if you are living with a man or a woman and he or she is not your husband or wife and they pass away, you would not be able to apply to administer that person's estate or fall as a beneficiary under their estate. All right, so you want to be very careful about that. Just recently I was on Facebook and I was looking at a comment that someone made under a post asking if marriage still then, if people still get married. And I found the comment interesting because the person was essentially saying that marriage has gone out of style, people don't get married anymore. They were essentially arguing, why go through the trouble of getting married when you can simply just move in with somebody? And there are some persons who are of the opinion that relationships are fine until people get married, and then when you get married, relationship kind of deteriorates after marriage. Now, whatever you believe, the fact remains is there are a lot of benefits legally to getting married. That's not to say that you should go and get married now simply because of that fact or because you are interested in an inheritance. But don't be fooled into thinking that there are no real benefits to being married. And so, just as an example, I have seen numerous situations where people separate but they don't get divorced. And so, there are a lot of people, they are still married but just separated. And so, the wife has gone one way, the husband has gone another way, they're still married, and somebody decides to date and get into a relationship with that married man or that married woman, sometimes fully aware that they are still married, and they proceed with that relationship. And sometimes that person dies and their estranged wife or husband comes back to administer the estate and claim all of the benefits. And one of the problems that people have is that they believe that these relationships should entitle them to something. So you live with this man, you live with this woman, you're not married, and you figure, well, his or her spouse left and went away sometimes 10, 15, 20 years. It doesn't matter that they have been separated for that length of time. It doesn't matter that their spouse never liked them, that there was no communication between the both of them. The fact is, on paper, they are still married. That is still his wife, that is still her husband. And so the fact that they have not been living together or even communicating with each other or like each other does not prevent that spouse from administering the estate or falling to benefit that one half or one third, depending on whether or not they are children, of course, under that estate. And so if you are in a relationship with a married person, this is something that you want to keep in mind, because their spouse would benefit, and under your common law relationship, you would not benefit unless you have an equitable interest in whatever assets that spouse has or acquires. That's very important to keep in mind. And it's also important for folks who are married but separated to keep these things in mind as well. Because let's say you have separated with your spouse and you guys don't live together anymore. You've been separated for however long, you don't like the person, y'all don't communicate at all, but you never went through the trouble of getting a divorce. If you die now, they would stand to benefit from your estate. And so if you don't want that to happen, you have two options. You either file for divorce, and if there are matrimonial assets to divide, you divide them in the process of getting a divorce, or you ensure that you do proper estate planning so that they do not come in, because you might be surprised. You might figure, well, this person has gone along the way. They're not interested in what I have. I'm telling you, they come. They show up and they administer and they seek to exclude all other people from the estate. And so I want to thank that person who messaged me to ask me that question. Because I think that clarifying the position of the stepchild is important, and it's also important for me to mention the position of common law relationships as far as intestacy and benefiting under that estate is concerned. Very, very important. And so that was last week's video. If you haven't watched it already, please go back and watch that video so that what I've said so far and what I will say from here onward would make more sense to you, right? So be very, 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 very careful when dating married people. Generally it's not advisable for numerous reasons. So that having been said, what are we talking about today? We are talking about deeds of gift. And just as a introduction to deeds of gift, I want to mention the fact that there has been an amendment to the Stamped Act sometime earlier this year, I believe in August. And so generally what the amendment means for you is that if you are engaging in any transfer of property, generally, you have to pay the government 10% of whatever the value of that property is, as assessed by the government's valuation department. And under a deed of gift, you still have to pay that stamp duty unless you fall within a category of persons who are exempt from that stamp duty. And so just for clarity's sake, a deed of gift is, as the name suggests, it's a gift. And when you have a gift, no money is being passed or no consideration. Consideration there simply means something given in exchange for. And so if money is given or if something else is given, technically speaking, it would not be a gift. So the thing to keep in mind is, here is somebody transferring property to somebody else without there being some form of payment for that property. So that's a deed of gift. And so if under ordinary circumstances, you pay stamp duty. However, if the transfer is between husband and wife, you don't pay any taxes. You don't pay the 10%. If it is between parent and child, you don't pay any taxes either. And recently, as a result of the amendment to the Stamp Act, which is a very welcome amendment, I must say, you don't pay any stamp duty either if you are transferring property from grandparents to grandchildren and even between siblings. And just like I mentioned last week, you have that responsibility still to produce your certificates to show that this person is my grandparent or my sibling or whatever the situation is, right? So those categories of persons are exempt from paying stamp duty. This is very beneficial as far as generational wealth is concerned and transferring property between family members. And so you want to be able to take advantage of this amendment and the Stamp Act generally, because it is one of the methods that you can plan your estate. And we're going to be looking at the benefits of doing a deed of gift versus doing a will, because we mentioned wills last week. And so when we're looking at deeds of gift and wills, each have their advantages and disadvantages. And so the main advantage of the deed of gift would be not having to, it's cheaper basically, at least in the long term. So when we spoke about administering an estate last week or probating a will, either one, whether there's a will or no will, you have to apply to the High Court to have that will probated, or if there's no will, you have to apply to the High Court to have the estate administered in accordance with the provisions of the Administration of Estates Act, which we went through last week. And so there is a time factor involved. Obviously there's a time factor involved because you have to apply, and having that grant of probate or that grant of letters of administration can take several months. And this is significant because in circumstances, for instance, where your dependents need access to money that you have left behind, perhaps money in a bank account, for instance, they would not be able to access that money immediately because they have to first get that grant of probate or letters of administration from the High Court office before they can access that money. And if they need it immediately for their sustenance or for any other particular reason, they are going to have to wait until that process is complete before they can get access to that money, or they can transfer whatever asset you left behind in their name. So there's a time factor. There's also a cost factor because legal fees have to be paid. You have to advertise in a newspaper. You have to pay taxes. You have to pay government duty to administer the estate or to probate that will. And so There's money involved and there's time involved. That is the main benefit of having a deed of gift done, because it eliminates that time factor, and it also eliminates the cost that your successors would have to pay in order to get their inheritance, because the deed of gift is immediate. You pay legal fee to your lawyer to prepare that deed of gift, but once you pass on, there are no other legal fees to pay. There is no time to wait, because that deed of gift has already transferred ownership in the property from you to your intended beneficiary. So that's the main benefit of a deed of gift. What then is the main benefit of dealing with your estate by virtue of a will? The main benefit of doing it by a will is that you have the opportunity to change your mind. That's the main benefit. Once you execute a deed of gift, a transfer of ownership has taken place. And so if you own property now and you sign a deed of gift for the benefit of your child, immediately your child has become the legal owner of that property. And the only way that you can get their name off the deed or get back that property is if they consent to sign. If they are not in favor of that, there's really nothing that you can do at that stage to get it back or to take their name off, not without their consent. And so the will has that benefit of being able to change your mind. So let's say you have a child now and you and the child have a good relationship, and you figure, listen, I want to leave this piece of land or this house and land to my child, and you make out a will. When I die, my property at Prospect to my child, Robert. 5 years down the road, you are still alive, Robert is still alive, and Robert is not being the best son. He's not treating you well. And you figure, you know what? I think I'm going to leave this property to Mary instead, because Mary has been a good daughter. She has been looking after me in my old age. She is here, keeping my company, taking care of me, taking me to the hospital, ensuring I have food to eat. But Robert is not really paying me any mind, or maybe he is treating you really terribly. When you have that will, you can make another will in Mary's favor. You can simply destroy the will. So you have that ability to change your mind later down the road if you no longer want to leave that property to whoever was named in that will to inherit the property. And a will takes effect only upon your death. So you make a will today. Whoever is named in that will does not have an interest in whatever their name is attached to. And so you can sell that property even though you've already included it in the will. And so if the property has been sold already before you die, the person who was named in that will as the intended beneficiary would not be able to claim any interest in the property, because at the time of your death, you are not the owner of it, and you will not be able to pass to them what you no longer own, right? So the will takes effect only at the point of death, right? So there's a lot more that I want to get through, but I'm looking at the time and the time is just flying by, and I don't want to make this video too long. So what I'm going to do, I'm going to stop here and I'm going to continue in next week's video with a part 2 to this video. I know this is part 2 of last week, but then we're going to have a part, I don't want to say part 2 of 2, a part 3, right? And then we'll move on to wrapping up this part of the series. So keep what I said in mind, especially for the stepchildren, the common law relationships, and looking at your options, deed of gift versus a will, and what are the benefits. So far I've only touched on one advantage of having a will, which is the ability to change your mind, and the benefit of the deed, which is the time factor and the cost factor, but there are more advantages and disadvantages that I wish to share with you so that you can decide which way you want to deal with your estate. But alas, we will continue next week. So if you have interest in this and you want to know, what should I do? What's the best option available to me? What are the advantages and disadvantages? I want to invite you to tune in next week when I will complete this video. So thank you guys for tuning in this week, and I'll catch you guys next week in the completion of this video. And do enjoy the rest of your Monday evening and the rest of your week.